Hello, good evening. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead, put your questions in the comments so that I may answer your questions. So, I have a great topic for you today, and it is applying for VAWA as the child of a U.S. citizen or legal permanent resident. What does that look like? Now, VAWA is not just for the spousal relationship. It's not just for women, even. It's for all genders. It is also for children of U.S. citizens, so abusive U.S. citizens or legal permanent residents. And it is also for parents of U.S. citizens or legal permanent residents who are, parents of U.S. citizens, not legal permanent residents, parents of US citizens who are, and the citizen child has to be 21 and up. So they have to be an adult child. Now, in this case, if you have been mistreated by a US citizen or legal permanent resident parent, this could be for you. Now, this would allow you to apply for your own relief. This would allow you to apply for your own work permit, your own travel document, your own social security number, and your own green card. Now, the rule here is that you have to file before turning 21. If you are 21 or over, then you have to have a good reason why you missed the deadline. If it's related to the delay was caused by or in some way related to the abuse or mistreatment that you endured from your parent. Now, what kinds of mistreatment are we talking about? Mistreatment could be so physical, if your parents beat you on a regular basis, or they beat you, they were cruel to you, they were controlling, they threatened your immigration status. These are examples of mistreatment. If they verbally abused you, called you names, yelled at you constantly, if they used fear to control you, then this is an example of the kind of mistreatment that qualifies you. If your parent intentionally neglected you, if they neglected your needs as a child, that can also qualify you for VAWA. So it's not if for example, if your parent they intentionally turned around and did not take care of you, they were a deadbeat, they had disregard for your emotional well-being and your physical well-being as well, because that's what happens in the case where you have a deadbeat parent. They are, in some cases, they're making that decision to neglect their children and neglect their needs. And now keep in mind that if you are under 21, there are two options here too. You can also apply. It depends on what's going on. If your parent was a deadbeat, neglected you, in the United States, there's also what's called SIJS, so Special Immigrant Juvenile Status. And this could also allow you to get your own permanent residence. So there are actually two options in a case like this, but it all depends on the facts. So 3, 2, 1, go ahead, put your questions in the comments. That's also why I'm here. I'm here to answer your US immigration related questions. So go ahead and put your questions in the comments and I will go ahead and answer. But today I am coming with a special topic, which is applying for VAWA as the child of a US citizen or legal permanent resident. Your parent does not have to be a US citizen in this case. They could also be a legal permanent resident. So my husband and I, after 9 years, are divorced, but fell in love with someone. How long should I wait to remarry? Okay, so usually in the case where your spouse sponsored you and you received your permanent residence, then you usually have to wait about 5 years before you can file an I-130 for another spouse. In your case, you spent 9 years. Now, 321, keep in mind that I'm just giving you general information. I would have to understand your full facts to determine whether you qualify to apply for your spouse, whether your spouse qualifies. So that's where you need to go ahead and schedule a consultation. But usually, if a green card holder received their permanent residence through someone else, through their spouse, then they got a divorce, then usually they have to wait 5 years, 5 years past the time that they received the permanent residence to be able to remarry. So 321, in your case, you're naturalized, you're a citizen. So you have every right to file for your spouse because you're a citizen. Yeah, so, it's been 6 years. Now, 321, remember though, this is not particular legal advice. So you should not be running off and getting married and filing papers until you actually sit in a consultation, because this is not personalized legal advice and I'm not your attorney. So while I'm giving you general information, it really is your responsibility to make sure that you get the right legal advice and representation. You can always call 561-405-4889. If you miss that number, you can always go to the link in the profile. It's going to take you to the website where you will then be able to get the information you need to book your consultation. And absolutely, 321, I represent clients in all 50 states and the globe. So you would be in good hands. Go ahead, keep putting those questions in the comments. I'm talking about a topic here, and it is as a child. And when I say child, if you're under 21, you can apply for your own permanent residence, your own work permit, your own travel document, if you're being mistreated by a U.S. citizen or legal permanent resident parent. And it doesn't matter if you're if this parent is married to your parent or whether you're living with them. If you do have to show that at some point you were living with them, but if you are a child, visitation also counts here. And so what I will do in a consultation is evaluate your situation and then determine whether you qualify. But if you had a parent who willfully neglected you, then you could possibly qualify for this form of relief. And now you can apply for this even if you're currently out of status, even if you overstayed your visa, if you cross the border without permission, there is the option to apply for this form of relief, to apply without your parent. So I need an I-94 and I don't have $400. Is there any easier way to get one? So you would have to now with the I-94, it sounds like you want to a replacement I-94. In this case, I wouldn't be able to advise you in particular. I'd have to understand your situation to be able to advise. But with the I-94, you could get a copy of your I-94 on the CBP website, but I don't know if you've tried that yet. What does it mean when it says no visa is available? My mom sponsored me, unmarried daughter. Yeah. So this is why it's taking so long, Sweet Lips. It's taking this long because you are you don't have an immigrant visa number yet. There is a long wait list for the immigrant visa number. Everyone has to have an immigrant visa number available before they can go on to get the immigrant visa to come to the United States. Or even if you're here, that immigrant visa number needs to be available to be able to get even go through adjustment of status. The reason that it is taking a very long time is because the number of applications they've exceeded the number of immigrant visas available per year. And what that has resulted in is years and years and years of people waiting for that immigrant visa number to be granted to them. Now, how you will know when it's available is when your when your priority date on your I-130 petition, that's the form, the document that your mom filed on the receipt notice, it's going to show the date. And there's a special website called the National Visa Bulletin. When you go there, you're able to see if it's current. Okay, so you want to do a live on adoption. Yeah, so with the definitely that's something I'll consider in the future. Adoption is it is definitely one of those complex areas, and it depends on the type of country, whether it's Hague or a non-Hague country. Because then if it's, for example, if some countries require the child to be an orphan before they can actually be adopted, and some they allow for the guardian, the citizen, so the parents intending to adopt to become guardians in the country before filing the I-130. And so it's a topic I'll definitely consider in the future. Thanks so much, user 776. Thank you for your support. So keep putting those questions in the comments. I will go ahead and answer your questions. I just came on to talk about applying for relief or VAWA relief based on mistreatment by a U.S. citizen or legal permanent resident parent. Now, there is an age limit here, and the age limit is if you are under 21, you can file for this. If you're already 21, but your parent did mistreat you before the age of 18, then you can still apply for this if you can show that the delay to apply was in some way related to the abuse. And if you can show that, then they will allow you to apply up until the age of 25. So you have to be under 25 at that point, but that may be an extension if you can prove that additional requirement. Now, this is where I've told you the what here, and I help with the how. So I'm not telling you to go and do it on your own because it is complex, and it's a complex area of law that you do have to be very familiar with. And so I can assist you to put your application together and to go ahead and file a good, strong application for you to get relief. This relief is available whether you're here with status, whether you're here without status, whether you overstayed, it is still available for you. Now, also one thing to consider, I know what you may be thinking is you definitely went through this tough time with your parent. Will my parent get in trouble? And the answer is it's unlikely for your parent to get into trouble because it's not a process that's meant for them to disclose it to law enforcement. It is a process where they're making a decision for the benefit of you as the immigrant. And so you don't necessarily, I would say, put it into the back of your brain that your parent will get into trouble, because that is not the purpose of this form of relief. As a matter of fact, the USCIS is not supposed to share it this information outside of the agency. Another thing is it private? Will your parent know? They will not know. And it's the same reason it's completely confidential. The other is, how do you prove this? What if your parent verbally abused you? And this is where once again, I help you to achieve the how. And we work with our clients to put good declarations together, to put documentation together that's available, because any credible evidence here is going to be important evidence at the USCIS. And when I say any credible evidence, it means any believable evidence. All right, so let's see here. So can I apply for advanced parole if my SIJS was approved? So if my SIJS was approved, but waiting for visa from Mexico. So the SIJS does not give you a status in itself. And because of that, the advanced parole probably would not, there's no ability to travel on SIJS based on advanced parole. Advanced parole is something that you may be able to apply for as an emergency. However, keep in mind that you would be doing this at your own risk. So And I don't know if you prefer to wait for the visa in Mexico, but at this point, you should really get personal legal advice to make sure you're doing it the right way. And here's another reminder, this is not personal legal advice. Don't act on this information that I am providing until I can speak with you in a personalized consultation. What do I do after getting married on a fiance visa? So after now, unfortunately, when it comes on to getting married and you're on the now, if you're on the fiance visa and you've gotten married, as you know, you're allowed to do. The next would be to file adjustment of status. You usually don't have to file the adjustment of status application. Um, with another underlying I-130. That's the benefit of the fiance visa here. But you do have to then go through adjustment of status to get the permanent residence. All right, so keep these questions coming. They're great questions. Can a child under the age of 1 travel on their parents' B1, B2? So no, the B1, B2 is for you and not the parent. So it's for you as a parent, it's not for the child. The child, you'd have to apply for their separate travel documents. My mother passed away and I'm getting married soon. I have 2 siblings in Haiti. I want them to assist me. I'm so sorry, Princess, that you have lost your mom. Now, when it comes on to the 2 siblings, it's not going to be a quick process to be able to sponsor them to come to the United States. In your case, it's going to be a little more complex analysis to determine whether your 2 siblings have any options going forward. You should definitely schedule a consultation and let's talk. Babilu, you're welcome. You're all welcome. I'm going to head on over to Instagram now. I'm the immigration attorney on Instagram. Join me there so I can go ahead and answer your questions. I am usually here Mondays through Fridays at around 4 p.m. Eastern time. However, I do have a number of engagements throughout the week and I will not be doing my regular lives for this week, but I will be back next week. So starting Monday, I'll be back at 4 p.m. Eastern time again. So I hope to see you there on YouTube. I hope to see you back here next week on TikTok so we can continue this conversation. In the meantime, go ahead, call, schedule, get on my calendar so I can provide you the legal advice you need to move forward in your case. Because remember, the information that I've given you today is not personal legal advice, it's general information. So I will hope to see you on Instagram in a minute, your last chance to ask a question before I head out for the week. Or I hope to see you in a consultation or see you on Monday again at around 4 p.m. Have a good one. Bye-bye.